Federalism, the origins of the federal system in the United States government. This figure shows three different options for organizing a government system. A unitary government or unitary system of government has a strong central government. State and local governments derive their power from the national government. In a confederation, the government derives its power from the states. Having experienced the challenges of a unitary government under King George III and the British, the newly formed United States initially tried a confederate system under the Articles of Confederation, and it did not work. And so finally, at the Constitutional Convention, the framers chose a federal system. This government is one where the power of the state and national governments come from the people, and those powers are shared. Why is federalism so important? Why do we care so much about this particular structure of government? Well, primarily, it decentralizes our politics. It means that sharing authority between a national and state government allows people more opportunities to participate and provides more points of access to policymakers. Because the national government isn't responsible for each and every state's education system, that means when you and I as citizens have complaints about education laws or criminal laws or marriage laws, we can go directly to our state representatives, our state legislatures, our state governors, our state courts to address those concerns. It also decentralizes our policies. Federal and state governments handle different problems. Again, states tend to handle moral issues, drinking ages, marriage laws, child custody laws, family law, moral issues, education, things of that nature. And the national government provides for overall safety, security, a fair and equitable system, interstate commerce, lots of different things. What's proven over time, though, is that states tend to be policy innovators. So a lot of policies that solve national problems tend to have emerged from the states. And having a federal structure of government allows states the freedom and the opportunity to be policy innovators. Some of the areas that the national government regulates, including equality, the economy, environment, a lot of those innovations have actually emerged from the states. A lot of the equality issues of the progressive era in the 1920s were from expansion in democracy and voting opportunities that came from the states. One of them in particular was Governor Robert La Follette of Wisconsin. So at the time the Constitution's written, the states held all of the authority. The framers felt they didn't have to list and restate all of the powers of the states because the states already held those powers, although they did ensure, in part to appease the anti-federalists, to specify some states' rights and states' authorities that are definitely given in the Constitution. So the states' powers are described in the greatest detail in the 10th Amendment, which says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. These powers, or this phrase, is often referred to the states' reserved powers, referred to as the states' reserved powers. In order to avoid any appearance of favoritism, the Constitution between states, among states I should say, the Constitution spells out states' obligations to each other. And so the Constitution authorizes the Supreme Court to settle disputes between the states, so that if there's a dispute between, let's say, Texas and Oklahoma, Texas state courts don't get to make that decision because obviously the people in Texas that would make up the jury would be more favorable to Texas than Oklahoma and vice versa. Article 4 specifically addresses the full faith and credit clause, which requires that each state give full faith and credit to the public acts, records, and judicial proceedings of every other state. This particular clause ensures that judicial decrees, contracts made in one state are legally binding and enforceable in other states. So that helps establish trade and other commercial relationships and recognizes the judgments handed down by each state. Article 4 also contains the Privileges and Immunity Clause, which guarantees that citizens of each state have the same rights as citizens of all other states. This is particularly important to you as young adults thinking about attending college next year, this means that when you go to another state, you're not allowed to be charged different rents or different fees for living in that state because you're a citizen of the state of Texas while you're attending school in, say, California. The extradition clause requires that states extradite or return criminals to the states where they have been convicted or to the states where they are accused of a crime. Interstate compacts are contracts that exist between states that carry the force of law, and there are currently more than 200 interstate. This graphic gives you a visual representation of the way that the Constitution divides powers between the state and national government. It enumerates or lists the powers of the national government, while many states are in the reserved powers clause, many state powers, are in the reserved powers clause of the 10th Amendment. And then you also have a category called concurrent powers, which gives both the state and the national government the authority to do these things, such as tax. Because in some states, not in Texas, but some states have a state income tax in addition to the national income tax. It allows both the national and state government to borrow money, establish courts, make and enforce laws, charter banks and corporations, and spend money for the general welfare of the people living in the United States and that particular state, such as Texas, respectively. So if we look at this chart, we see that there are more than 87,000 governments that exist in the United States. Most of these governments are found at the local level. Obviously, you have special districts, school districts, townships, municipal or city governments, and then also county governments that exist. They create the bulk of governments that exist in the United States. The most common form of government is the special district. So let's consider each of these different types of government structures. Local governments actually have no express power under the Constitution. It's one of those sort of implied powers. According to Dillon's rule, which was given by Judge John F. Dillon in 1868, local governments are required to have a state charter to operate, and this charter is similar to a constitution. Counties tend to be the basic administrative units of local government. We have 254 counties in Texas. Municipalities are city governments that are created in response to relatively densely populated areas that require more people and more manpower than just a simple county government. But county and municipal boundaries for that reason may tend to overlap. The term town refers to much smaller communities that are often run by a mayor and perhaps a town council. And a special district, which is the most common form of local government, is restricted to a particular function such as a school district. Special districts, again, are the most numerous form of government. So as we look at federalism in interpretation, we will specifically look at the Supreme Court under the leadership of Chief Justice John Marshall and how the court in the early 19th century played a significant role in defining the relationship and powers of the national government, where the national government's authority did and did not extend in a federal structure of government. The courts broadly interpreted the Supremacy Clause from Article 6 and also the Commerce Clause, which is in Article 1, and expanded the powers of the national government. So in 1816, Congress, we're going to talk first about McCulloch versus Maryland. In 1816, Congress chartered the Second Bank of the United States. In 1818, the state of Maryland tried to tax the Second Bank of the United States, James McCulloch, who was the head cashier of the Baltimore branch of the Bank of the United States, refused to pay the tax, and the state of Maryland sued him. In a unanimous opinion, the Supreme Court answered two central questions presented to it. Did Congress have the authority to charter a bank? And if it did, could a state tax the bank? Okay, so Congress in Article 1 has the ability to borrow money. That's an actual enumerated power that is given to Congress. And the Supremacy Clause says that the supreme law of the land is U.S. Constitution and treaties followed by state legislation. So if those two were in conflict, then the national government legislation or actions of Congress would be determined as supreme. So the state of Maryland did not have the right to tax the national government. Okay, let's look at the second case, which also affirms national power, Gibbons versus Ogden. What happened is that it was a dispute that arose after the New York State Legislature gave Robert Fulton the exclusive right to operate steamboats on the Hudson River. And at the same time, Congress licensed a ship to sail on the same water. So it's the actions of the New York State Legislature versus Congress. Gibbons, the court addressed the question, what was the scope of congressional authority under the Commerce Clause? The states argued that commerce mentioned in Article 1 simply referred to the narrow interpretation of direct dealings with products. The Supreme Court did not agree with this, and they sided with congressional ability to regulate interstate commerce, which included regulating commercial shipping or commercial actions. Barron versus Baltimore is a very important Supreme Court case as far as the expansion of civil rights and civil liberties, as well as federalism, because essentially the Marshall Court rules that Barron had no federal claim because enumerated rights that are contained in the Bill of Rights are only bound to the national government. So this particular decision says that only the national government has to be responsible for upholding, or only the national government is where the Bill of Rights are applicable.